Hi, and welcome to Workstream webinar on how to maintain a legal hiring process. So quick little background on what is Workstream. Workstream provides tools for local businesses. We work with a lot of QSR franchises, assisted living, and pretty much everything in between. So Workstream helps you post to job boards, screen candidates, engage via text message, schedule interviews, and onboard new hires. All along the way, there are a lot of laws that impact businesses. And so we get a lot of questions to our customer success team. And the customer success team, we have people who are available 24/7, literally just answering questions in the chat. More and more people have been asking us about new changes to their laws. They've been getting a lot of alerts. They want to know, am I actually still in compliance with my state laws? So as the lawyer on the team, I'm presenting what you can do. That being said, Workstream is not a law firm. We do not provide legal advice, and we are not a substitute for advice from an attorney. So this presentation, we're really sharing laws as they're written, along with insights from the hiring managers we work with about how they keep up to date on regulations and how they make sure that their hiring managers are still in compliance with those laws. And so what we have are a lot of the actual laws, as well as highlighted sections that often go ignored, where we see a lot of people sort of, making common mistakes. And we want to help you guys avoid that, so you're on the right side of the law. First and foremost, federal law. Most of the companies we work with are based in the US, so we really focus on the Equal Employment Opportunity Commission. Under the laws enforced by EEOC, it is illegal to discriminate against someone, applicant or employee, because of that person's race, color, religion, sex, including gender identity, sexual orientation, pregnancy, national origin, age 40 or older, disability, or genetic information. By the way, if you see 40 or older, that's something that a lot of state laws are also changing. It used to be over 40, so that was another recent change. It's 40 or over. I'll tell you a little bit more about how that plays into questions you ask. Everyone thinks, okay, yeah, this is pretty obvious. But one thing that gets overlooked is that you're prohibited from using neutral employment policies and practices that have a disproportionately negative effect on applicants of a particular group listed above. So if the policies or practices at issue are not job related and necessary to the operation of business, there's a chance that you risk getting called out. And this is really important, especially for the franchise businesses we work with, because huge brand names draw a lot of attention. It is illegal for an employer to publish a job advertisement that shows a preference for or discourages someone from applying because of race, color, religion, age. Again, seems really obvious, but the thing that we often see as a mistake is that people will say things like recent college grads. This is a great job for recent college grads. That's considered discriminatory. So that's one of those phrases, avoid it. And this comes directly from the EEOC website. Another general rule, and again, directly from EEOC, is that the information that you are obtaining as you go through the pre-employment process should be limited to essential questions to determine whether or not they're qualified for the job. So as you move people along, make sure they're qualified. Questions about the organizations, clubs, society, and lodges, lodges, it's outdated, but it's the EEOC website, if they indicate an applicant's race, sex, national origin, disability status, age, religion, color, or ancestry, they should generally be avoided. So again, something that we see often is people will be asking about the organizations that somebody was part of in college, or the clubs or societies. Again, those things need to be avoided as a questionnaire. Do not explicitly ask for that. You can ask, what do you participate in your free time? What organizations do you participate in your free time? And have as an exception, unless this is something that would in any way indicate your race, sex, national origin, disability. You can have a disclaimer if you want to ask those questions and say, unless this somehow would indicate that. So ask if you include the disclaimer, or just don't ask and just instead say, what do you do in your free time? For more information, the Equal Employment Opportunity Commission is really easy to navigate, eeoc.gov. they'll go into all of these specifics about race, height and weight, financial information, all of the questions you can and cannot ask to comply with federal law. But I want to just quickly jump into one of the sections that, again, is something we see often people make the mistake of doing. Commonly overlooked, the following pre-employment inquiries may be regarded as evidence of intent to discriminate. So questions, okay, whether they're pregnant. Again, like, I like that little cartoon. Don't ask me about my massive weight gain. These are pretty obvious ones, but the highlighted sections are often, we see people asking these. Childcare arrangements, you can't ask about that. You can't ask, what does your husband do for work? And you can't say, oh, like, what's your husband's name? Do I know them? Those are actually evidence of intent to discriminate. And so you really want to make sure that your hiring managers are trained on those questions and don't ask those because they often slip through the cracks. Now let's get into state laws. This is where it gets really tricky. In the past year and a half, there have been a lot of updates as states expand their anti-discrimination and harassment regulations. So state by state, California now protects hairstyles. Connecticut expanded its sexual harassment training requirements for employers. Illinois now has just one employee that it takes for it to be, applicable. They've also enacted a number of new harassment protections in the wake of Me Too. These have all gone into effect in 2020. New York, they now prohibit discrimination on the basis of reproductive health decision-making or domestic violence. Washington passed new anti-harassment protections and training requirements for the hospitality and retail workers, as well as those working for property services contractors and security companies. And so that goes into effect first for those groups, January 1st, 2020, and then for all of the other covered employers at the very beginning of next year. Additionally, there are pay equity and salary history things. Don't ask about how much people got paid before. That's just a good thing to do, good thing to avoid. New equal pay protections for Connecticut, including a ban on salary history questions. New Jersey employers are barred from asking questions about a worker's wage and salary experience. New York prohibited from seeking salary history from applicants. And then there are the privacy regulations. So California, Illinois, I'm going to really focus on California because honestly, that one is the broad one that is starting to be applied in other states. And I think that will happen over the next few years. The California Consumer Privacy Act makes companies need to basically take steps to let the applicants know what information is being collected and give them an option to opt out of the communications and how their information is being used and processed. So if you're based in California, look at the CCPA to just figure out exactly what disclaimers are, or if you're a Workstream user, just ping your lovely customer success person and they can tell you what disclaimers to include. We're really helpful about just letting you know, like, just add this sentence here and you should be good. Okay, and then there's California's newest update. So this went into effect last month. Under California Department of Fair Employment and Housing's new regulations, all the things that used to say employment are now pre-employment as well. So really expanding that. And so what this means is that the questions you're asking, it's not okay to ask questions in the pre-employment screening process. The types of questions that you wouldn't be allowed to ask a current employee, you now can't ask an applicant. It seems pretty obvious and easy, but here are the ones that are often overlooked. So you can't request an applicant's age, date of birth, or their graduation dates. So make sure when you're getting applicants' information in, you're not asking for their date of birth, and then you're not asking them what their graduation date is from college. They could include it on their resume, but you can't explicitly ask them to fill in their graduation date if you have a form asking about their college and or high school experience. You can't have a maximum experience limit in job ads. So you can't, when you have a range You can say like at least 6 years of experience, but you can't have a range of like 6 to 8. Those are seen as being negatively impacting people who are age 40 and older. Also, if you request scheduling info, and this is huge for us because at Workstream, one of the things that we do is we automate the whole scheduling process for, interviews, follow-up meetings. If you're meeting with multiple hiring managers, we just automate it. We're like sending links, and so like people get those. But when you request scheduling info, whether it's for the interview or it's what your availability is for work, you can't have any questions that would somehow disclose a religion, disability, or medical condition. Here's how to make sure you don't do it. Have either of these two quotes. If you are a California-based company, or if you just want to get ahead of what's happening around the country, add either the first, other than time off for reasons related to your religion, disability, or medical condition, are there any days or times when you are unavailable to work? Or other than time off for reasons related to religion or a disability or a medical condition, are you available to work the proposed schedule? So that quick little disclaimer, and this is directly from the California website, government website, really helps make sure that you are on the right side of the law and that you're never going to be in trouble for asking questions that somehow discriminate people based on one of the protected groups. So how are we helping Workstream customers take care of this and prevent against this? Well, the biggest thing is that we actually give franchise owners, general managers, basically anyone who's in charge at the top, a way to have a line of sight into all of the communication. So, for example, Jamba Biology Carl's Jr., we work with a lot of those. One of the multi-unit franchise owners in a recent interview where she was telling all of the other Jamba franchise owners why she was promoting this at the corporate level, said, before Workstream, managers were using personal cell phones. There was no line of sight. With Workstream, district managers and owners now have oversight to the entire hiring process, even down to seeing each message in the hiring process. This is hugely important because you can actually see what your GMs are asking when they're doing two-way messages, emails, anything. What you can also really do that's important is you can automate the questions that are being asked and send out the screening quizzes. So one thing that Workstream, what we help employers do is we actually have these different stages where you have the applicant stage, the additional information, which is a form stage, video Q&A. And with each of these sections, they'll have questions that not only, the owner and everyone recommends, but you can actually take the templates used by companies like Chick-fil-A and Jamba, and we have the customer success team setting these up to help you make sure that, again, you're on the right side of the law. And so instead of GMs asking random questions, they're collecting information that already includes the disclaimers and keeps everything very much organized for you. Then you can see all those applicants and all their answers in one place and know that they are not being asked any inappropriate questions. So the way that Workstream works is when people apply, they get a text message. So they'll see something like, hi, I'm Hope, thanks for applying, when can you start? That's not a scheduling question. That one is still okay. Then you can ask a question like, have you ever worked at one of our stores before? And then you can say, again, nice, could you write 2 sentences or upload a 30-second video about why you're interested in the role? The first 3 questions right there are all automated. This looks like something as though like, okay, the person applied, they got these instant things, but actually they were all automated and just behind the scenes, somebody at the owner level had preset these questions. Then the person has the option of either doing 2 sentences or uploading a 30-second video. This is also really important because one of the things that the EEOC says not to do is to collect pictures ahead of time. Or if you do anything like that, you have to say it's optional. So what we have is, because we're sort of in the world of video interviews, we're trying to make it easier for people to send just sort of like a one-way video interview introducing themselves. but we always have the option of doing that, or, you know, 2 sentences saying what it is that interests you. And then again, even the next thing, that was great, we'd like to invite you for an interview. This is just a hiring manager behind the scenes swiping and moving somebody to the next stage where they are going to get this automated message that again looks personalized with a link to the hiring manager's availability. This is really good too because it's sending the availability of the person who's going to be interviewing them in person versus asking them for their availability to meet, which, as we already covered, really gets into sort of sticky issues with the whether or not they're disclosing something that has to do with like their religion or other protected information. So anyway, that was just a really quick overview of federal laws that are often overlooked, as well as state laws that have changed in the past year and what you can be doing right now to make sure that you're in compliance. You can contact me, Lydia, at workstream.us, call or text 415-767-1006. But I'm happy to answer questions that people have. So let me just jump in. If you want to ask any questions to the Q&A, you can ask anonymously or ask with your name. So we have somebody asking, what about age questions related to working with kids or liquor, i.e. the minimum of 18 years or 21 years of age? So yes, you can ask questions as long as they are related to your business and operations. So if you need somebody to be over the age of 18 because they're serving liquor, or 21 in certain states, you can ask those questions. You're allowed to ask questions as long as they are necessary for what the person will be doing in your business. And really with the age discrimination questions, they're about preventing discrimination with people over or 40 or over, not over 40, it used to be over 40, but ages 40 or over is really what those laws seek to protect. For recent grad, another question. For recent grad, can we use this question if we are hiring for an internship? Yes, for an internship, as long as you are doing it with college credit. Now, internship laws are really interesting state by state. Many states now require that you pay interns and or that they are getting college credits for this. I'm not quite sure what you mean about for a recent grad, but in general, what I would say just to do is to make sure to avoid asking for specific graduation dates, and instead you could ask somebody whether or not they are currently enrolled and would be able to get college credit for this. Yeah, do we have any other questions? Okay, another question that came up, when did the California privacy thing go into place? So it went into place January 1st, it went into effect, but they're only starting to enforce it as of July 1st. So that's why it's really just in the past month or month and a half that we need to make sure everyone is complying with that. Okay, another question, is it okay to limit internship job ads only for junior, senior college statuses? That's a state by state question, I believe. I'm pretty sure you're allowed to do that. Again, like most of the age related questions have to do with protecting people age 40 or over. And so it's less so about protecting somebody between the ages of like protecting an 18-year-old from being discriminated against if there's a person who's 20. So you should be fine for that. And I believe you're fine, but you may just want to search your specific state law because there are some funky state laws for that. But generally, I would assume you'd be okay, at least at the federal level, you're okay. Do people have any other questions? And you can ask questions anonymously. Okay, well, great. Well, anyway, my email is lydia@workstream.us. You can also Right after this ends, I'm going to just send you over to a contact form. You can submit additional questions, and I will get those, and I will be able to answer all of your questions. So please send away, and be happy to answer any questions that come up. Thanks, guys. Have a great day.